You are not halfway through point 4, I think.
No, I was on the, exactly, the first short point under point 4 was, at the outset, both courts and Parliament alive to the powerful public interests that we went through. We went to Lord
Yes.
Bingham and Onibayu. Secondly, under that heading, from the outset, the concept of claim in the legislative scheme governing appeal rights has not been treated as a self-creating concept. So couldn't just treat any submissions as generating a fresh claim, generating therefore fresh appeal rights. That was why Onibayu established the acid test. That was then incorporated into the immigration rules. And once it had been incorporated, the Court of Appeal then considered the matter in Kakabe. I don't, I think, need to go back to that, or to go to that in oral submissions. It's in Bundle 2, Tab 9, Electronic 758, if you want it. But in that case, the Court of Appeal concluded, and indeed the parties, I think, agreed, the parties being represented by Messrs. Plender and Nicol, that what they described as the categorisation decision, is it a fresh claim or not, applying 346, needed to be made, and there was nothing inconsistent with any international or other obligations in doing so. And that unless the claim was a fresh one, per Lord Bingham, there were no appeal rights.
Needed to be made by whom? Because that's
needs to be made by the Secretary of State.
That's the crucial question.
Yes, by the Secretary of State.
That's basically what this case is all about.
Yeah. I know exactly. I can't remember whether in Kakabe as well there was that point was specifically raised. I've got a feeling.
Well, I think it's important.
I think. Well, let me just check then. Yes, I think it was. You'll see if you go to it on, pick it up at 762 in the electronic. It's in Bundle 2, Tab 9. 762 in the electronic, there's a bit of an analysis as to why you need a categorisation decision at 762. And if you cast your eye to the left-hand page, or if you're electronic, the page before 761, you'll see in the first half of the page the recitation of what had post Onibayu been created, which was 346. So they're thinking about 346 and the fact that it gives rise to categorisation decisions. Then they analyse why it is that you need a categorisation decision of that kind, and you see from the about a third of the way down 762, first paragraph under the title, the need for categorisation, helpful to indicate why the need for categorisation arises. What follows is not substantially in dispute between the parties, and then sets out the analysis that you see follows for about a page then. And then I think the analysis that then follows then considers what they describe as the appeal question, starting on 763, which then goes into the debate around whether it's a question of precedent fact, as one sees from the title on 768. I think maybe that my lady, they do consider that issue.
Well, earlier on, it's been common ground.
That it was for the Secretary of State?
Yes. The initial categorisation decision must be made by the Secretary of State. If he makes a mistake of law in coming to that decision, that can be corrected by the courts by way of judicial review. That's page 764.
Yeah.
It says that's common ground.
And then there's a question as to precedent factors you see from 768.
But that relates to what the judicial review is all about.
Right.
764 appears to be common ground that
It's for the Secretary of
it's
State.
for the Secretary of State,
Yeah.
subject to judicial review.
So that's the next chunk of the legislative and judicial history, as it were, the development of what became 353, the consideration in Onyebayo leading to that rule, Kakabe explaining how it all works. And then we get the twin decisions or the two decisions in ZT Kosovo and BA Nigeria, the latter being Supreme Court, the former being House of Lords. I think the very last case considered in the Chamber in the House of Lords. So BA Nigeria is 2009. And again, I can take this pretty shortly, I think, because our essential submission about those two cases is that Lord Neuberger's analysis and the Court of Appeal's analysis in ZA Nigeria is correct for the reasons that he gave. And it may be as well just to have ZA Nigeria to hand, if you would. It's in Bundle 4, tab 23, beginning at 1427 on the electronic as the first page. And he specifically, and the Court of Appeal specifically rejected, we respectfully submit, on a fair reading of it, it's quite a long and intricate judgment, but they specifically rejected the argument that the Supreme Court in BA Nigeria had rendered 353 a dead letter for the purposes of the whole of Part 5. And you see the nature of the judgment and its structure. I don't know if friend has helpfully already introduced the indentations in the italicized headings.
Sorry, could you give me the page reference again? I seem to have got it wrong.
Yes, I'm so sorry, my lady.
No, it's not.
1427 is my first page.
I wrote it down the wrong way around. Thank you.
You'll see the nature of the analysis is in effect to take it from first principles, from paragraph 21 through to 30, and I'll come back to the significance of certification, which is going to be the subject of my fifth submission. But just on the structure, you see the nature of it. He takes it from first principles, he looks at the relevant statutory provision, and he says, well, is 353 a dead letter? That's the case he's addressing. And then he moves to the case law. That's why you have the introductory paragraph, which is 31, because he reaches the conclusion in para 30 that all other things being equal, and taking it at first principles, 353 is not a dead letter. And then the introductory linking paragraph is 31. And then he turns to analyse ZT Kosovo, which he does between paragraphs 32 and 38. And BA Nigeria, which he does between 39 and 47, and then sets out the submissions made by the Secretary of State that you see recorded in 49, including in particular the issue which it was submitted on behalf of the Secretary of State had in fact arisen, the narrow question that had arisen in BA Nigeria, That's set out between C and D on page 1445, para 49. And that essentially was a submission that was accepted for the reasons that he then set out at paragraphs 51 and following. So just to track back a bit, in essence what was being said, if I may summarise, was that the effect of ZT Kosovo had been to apply the Onibayo approach to cases in which the Secretary of State had certified under Section 94 that the claim was clearly unfounded, so there's a right of appeal, could only be exercised out of country, had to pass the 353 threshold, and that was wholly consistent. The reasoning in ZT Kosovo was wholly consistent with 353 continuing to have a significant part to play in the context of Part 5, the combination approach that we saw from VM Jamaica. And you see that conclusion at paragraph 38 on 1448, or 1442. So he's got then one House of Lords decision which deals with that in the majority, with I think Lord Hope, although ultimately agreeing on the result, taking a different view on the applicability of 353, as you see from para 37, 1442. But he then concludes, and this is the central conclusion, that the effect of BA Nigeria is restricted. And it's restricted in the way in which Lord Neuberger describes it. And the key...
On the basis that, although the words may be wide, unless you restrict it, there is an inconsistency with the former decision.
Exactly so. That's the core of the reasoning. I mean, in fact, it's put a little more, I do him an injustice, there's a little more to it than that, because the key reasons that he gives are summarised in the Roman 6 propositions that he sets out in 53. But just before you get there, the key restriction is the one he describes in para 41 on page 1443, to which my learned friend took you. And then when he comes to the discussion about how you reconcile those two decisions, the answer is a narrow reading of BA, because otherwise they don't reconcile. But see all 6 of the points in 53, which are then developed to the extent that he considers it necessary and appropriate to do so in the paragraphs that follow. And you'll see that they are, certainly the first few of them, are centrally on the point my Lord Wilson has just put to me, but there are additional points to do with legislative provisions that came in subsequently, which indicate that Parliament is proceeding on the basis that 353 does indeed have a role to play. Look, for example, at the development of point Roman 6 in paragraph 57. So just to explain that as you read it, section 53 of the 2009 Act it was all about transferring decisions back to the upper tribunal, in effect 353 decisions back to the upper tribunal on a judicial review. So they pass a piece of legislation afterwards which has that effect, and that is recognising much more clearly than section 12 might be thought to do, that Rule 353 was assumed, as he puts it, just below E, by Parliament to be effective. And then the key reasoning in para 59, that's the key and conclusion. So BA is given a restricted meaning. It isn't, and it advisedly and specifically isn't, taken as authority for the proposition which is at the foundation of my learned friend's case, which is that BA stands as authority for the proposition that claim means claim in Part 5, and that's the end of that. He's drawing a much more nuanced and narrow basis for the majority's decision in BA, and perhaps unsurprisingly, given the nature of the argument that was run in BA, I'm not going to take you back to it, but we've set out or given you the reference to the way in which the argument was actually framed as being a narrow point, not a point that applied to the whole of Part 5 or anything of that description, in our case at paragraph 48. So that's the way the argument was presented in BA, and not surprisingly also because when and if you go back to BA, it is quite important to focus, we respectfully submit, on, given the nature of the issue as identified correctly, we respectfully submit in ZA Nigeria, quite important to go back to paras 30 and 31 of Lord Hope's judgment in BA, which set out the incoherence that would arise in the particular context that he was considering if 353 did indeed have a continuing role to play. Again, I do no more than invite you to note that at the moment. And I do so because it is, if anything, an additional point to the series of points made by Lord Neuberger in ZA. But those are points which are in 30 and 31 about incoherence of the legislative regime if 353 had no role to play in that context. They're points that are very specific to that context and are not points which tend to the generality of Part 5. So we respectfully submit that the analysis and the reconciliation between those two competing, if I can put it that way, decisions of the top court, we respectfully submit that Lord Neuberger's analysis is the correct one, both for the reasons of principle that he gives in the early part of his judgment and because it provides the reconciliation which forms the thrust of his reasoning in the second part of that judgment. And the distinction, it might be thought, is crisply put by Lord Justice Beatson. If you go on in that same bundle or back in that, forward in that same bundle to the Hussein decision and the quotation from Lord Justice Beatson refusing permission in Wakar at 1499 on the electronic, so it's tab 26 within the same bundle 4, tab 26, page 1499, and we're now in the written reasons for refusing permission in Lord Justice Beatson in Wakar, cited in the Hussein case. You'll see his description of the core reasoning and distinctions drawn by Lord Neuberger in paragraph 20, bottom of 499 over the page. Respectfully submit that that's a helpful and accurate distillation of the reasoning of Lord Neuberger so far as it concerns BA Nigeria, and mirroring that into substantially the same effect. Again, I just invite you to draw a line next door to the paragraphs, but to substantially the same effect, paras 35 to 37 in the actual judgment of the upper tribunal in this case, pretty much along the same theme, and again, a crisp distillation of that reasoning. That's on page 1503 to 1504, and the paragraphs are 35 to 37. And to those distillations of the reasoning of the Court of Appeal in ZA Nigeria and its analysis of ZT Kosovo and BA Nigeria, we would add, if I may respectfully pray and aid the perfection of the dissent in BA Nigeria. That result, we respectfully submit, is at least consistent with Lady Hale's dissent in BA Nigeria, but it leads to the result that the Court of Appeal conclude that Lady Hale's reasoning based on Onibio and all the rest of it continues to run, continues to be operative and good, save only for the narrow and limited exception carved out by BA Nigeria. And that is the correct, that the ZA analysis that you see summarised by Lord Justice Beats and Peter Lane and Mr. Justice Dove in Hussain, that is the right analysis.
Sorry, where do we see that? We're still in.
No, that was, my Lord, I'm sorry, about Lady Hale's dissent.
Yes.
No, that was a submission.
I'm sorry.
Unsupported by judicial authority of any kind. But that was a submission. I'm sorry, I should have made that clear. The only other thing perhaps it is worth bearing in mind in relation to ZA itself is that as the law report, go back to tab 23 and page 1448, the very last page of the law report, you'll see that permission was sought from the Supreme Court to appeal. I know one shouldn't attach too much importance to refusals of permission, but permission was sought from the Supreme Court and was refused by a committee which included Lord Hope.
Yes, but you can't really attach any importance to that because you don't know why, you don't know the circumstances.
My lady,
Unless you've got a copy of the order which tells you why, which it often doesn't.
we haven't got a copy of the written reasons if there were any, I'm afraid. But anyway, it was refused.
He obviously wasn't outraged.
He wasn't outraged, is the highest I can put it, perhaps. So the ratio we respectfully submit of BA Nigeria is the narrow one that Lord Neuberger identified, that Rule 353 has no part to play once an appeal right has arisen against an immigration decision in that way. And we respectfully submit that that is a correct analysis. And I'll return to the change in structure in 2014, on which my learned friend relies, the 14 down to 3. But it is evident that, from any fair reading of Lord Neuberger's analysis, that the analysis did not simply turn, cannot be explained away on the basis of that distinction. It was based on an analysis of claim and a reconciliation between the House of Lords and Supreme Court authorities. And we see that it was based on an analysis of the concept of claim, inter alia, from paragraph 21 in Lord Neuberger's judgment in ZA. So although it is true that there are lots of references, including in the summary, the crisp summaries and the future courts, as it were, to which I've drawn attention, to immigration decisions, that is because that was the way in which the legislation was structured at that time. But the essence of the reasoning is how narrow is the exception in BA, how do you reconcile it with ZT Kosovo, what should the answer in principle be outside the situation where an appeal is going ahead anyway, and the question is where, answer as given by Lord Neuberger both in principle and reconciling those authorities. And that was the position, which is the final point in relation to legislative history, that was the position and had been the position for some time. I think it was 2010, the ZA July 2010 judgment is given on presumably the last day of term or thereabouts, 2010. That's been the position for some years at the point at which the 2014 Act is then enacted. So claim at that point, we respectfully submit, has the well-settled meaning, subject only to the limited or narrow exception set out by BA, or in BA Nigeria, as analysed in ZA. We've sought to summarise, I'll just give you the reference without going to it, we've sought to summarise where that all ended up after ZA in our case at paragraph 52. So that's the paragraph at which we seek to draw together the way in which the law stood from 2010 onwards and at the point at which the 2014 Act was enacted. fifth submission we make turns to certification and the question whether it provides a complete answer. There have been, as we note, certification powers of some description throughout in the legislative schemes. So at the time of Onibio, there were the powers that my learned friend drew attention to in Schedule 2 of the 1993 Act. Then if I just turn it up, it's Bundle 1, Tab 5, page 723. Those certification powers enabled certification of a claim as without foundation, resulting in the denial of appeal rights, subject to the agreement of a special adjudicator. That was the nature of the structure at that time. And yet that didn't affect the Court of Appeal and Lord Bingham dealing with the fresh claim issues as they did in Onibio. More significantly, perhaps, we respectfully submit that there's no undermining by sections 94 or 96 of the important gateway function that all the previous case law and subsequent case law has analysed, performed by 353 within the context of Part 5. And that is because sections 94 and 96 do not provide a complete code covering the totality of the situations that 353 covers. It's perhaps important to note at the outset of considering certification powers and this complete code argument that the two things, complete code and continuing role to play, are not necessarily precisely the same things. Let me make that rather less opaque. If you go back to ZA Nigeria, Bundle 4, Tab 23, page 1439, and you go to paragraph 24, there is quite an important conclusion we respectfully submit about the correct approach to this issue. In other words, does it need to be complete coverage? Does 353 still have a role to play even if certainly some things can be done under 94 and 96, but does that mean that 353 no longer has a role to play, or do you approach it in a slightly different way? So the conclusion of approach that Lord Neuberger and the Court of Appeal reach is to say the issue between the parties should not be determined simply by seeing whether sections 94 and 96 can be interpreted to cover every application and purported application falling within Rule 353. It's equally valid to consider whether they can be construed consistently with 353, continuing to have an independent effect. That's very much, I suspect, the point that my Lady and Lord Justice Sales, my Lady Lady Arden and Lord Justice Sales had in mind in paragraph 28 of VM Jamaica. They work in combination, was the argument, and Lord Neuberger is saying that is right, and they can continue to work in combination, even if the diagram is Venn in nature. Having set out that conclusion of approach, Lord Neuberger conducted a pretty extensive analysis of the arguments based on 94 and 96 in the paragraphs that followed, and indeed in paragraph 23. So the core conclusions, if I could just draw them out and give you the paragraph numbers on that part of the analysis in ZA, are that Parliament did not repeal or amend 353 at the time it enacted the 2002 Act, brackets including sections 94 and 96. See for that purpose paragraph 23, and indeed it approved...
Can Parliament repeal a rule? Wasn't that what you said?
Yeah, it did not repeal or amend, or did not require the amendment of 353. I mean, we know the status of the immigration rules, but the point is that they were left on the stocks unaltered. Formally have the power or would call for the Secretary of State to do so and present new rules. That did not occur. And indeed, Parliament did approve subsequent amendments to the rules, which did not include the deletion of 353. That's the point that's made in paragraph 23. Yes, so this point is a combination of paras 23 and 18. I think my Lord is right to draw me up on that. I think he puts it neutrally in that first sentence of paragraph 18. No attempt by anyone, it probably would be the Secretary of State who would have to bring it to repeal or amend. Next, as he notes in paragraph 18 as well, section 53 of the 2009 Act, which he there refers to, that's the one that reference was made to in the later paragraph, you'll recall. That proceeds on the basis that 353 is still in force and has practical effect. See for that purpose paragraphs 18 and 19. Particularly the last sentence of 19. And 23, which contains the punchline in the last couple of lines of para 23 on the claimant's case. When Parliament enacted 53 of the 2009 Act, it was simply beating the air.
Sir James, I know your submission is that we should not look at uncommenced legislation, but might it not be a reason for not commencing legislation? Might it be a reason for not commencing legislation that it might have inadvertently disregarded the honour bios ruling principle?
Is my lady thinking of section 12 now? Yes, I'm going to make submissions on section 12. The submissions are in essence going to be that, if anything, what that demonstrates is a parliamentary intention that the thing dealt with in section 12, in other words, the equivalent, the statutory equivalent of 353, I summarise, should be in place in the legislative regime if necessary. And so given that it was enacted but hasn't been commenced, the question that is then posed is a pretty much binary one. Why was that? And we respectfully submit that it would be very surprising indeed if, having exhibited that intention, it was not commenced for any reasons other than that they were simply clarifying provisions in the first place.
Yes, or there could have been an error and the Secretary of State would not want to commence a provision for all sorts of reasons.
There could have been, although the explanatory notes look as though they were intended at the time to be clarifying in nature. Whether that was necessary or not, they may have thought, well, we don't need to anymore because it's tolerably clear what the answer is anyway, as a result of the developments in the case law subsequently, including ZA.
Yes, yes.
Still back on the 94 to 96. I mean, so far we've got points, as it were, on the periphery of 94 to 96, but you'll appreciate that at paragraphs 25 to 27, the Court of Appeal specifically analyse whether indeed the coverage is coextensive or whether there are different bits of ground, even if there's some overlap, whether there are different bits of ground being covered by 353 on the one hand and 94 and 96 on the other. And they conclude, the Court of Appeal conclude, that in both respects, that's in relation to 94 and 96, they cover different ground. So 94 is a subject of analysis at 25, 26 and 27. And 96 is the subject of analysis in 29 of this judgment on 1440. Just to go back to 94 for a moment, I think, as my Lady Black drew attention to this morning, of course, 353 shuts down an appeal. I mean, it isn't just to do with where. So even if wholly unfounded is to be regarded as exactly the same, and there may be serious questions about that for the reasons my Lord Wilson gave, as no realistic prospect of success. Even assuming that, you've still got a lacuna in relation to the Section 94 certification bit, because all that does is where? The appeal still proceeds, it just proceeds from outside the United Kingdom, whereas 353 shuts down the appeal if it doesn't cross, and there is no claim, therefore, in relation to further submissions, if they aren't significantly different, to take that phrase, as defined and described. So all of that feeds into the 94 analysis at 25 to 27 of ZA, the 96 analysis at 29, which, as you know, doesn't deal with pure repetitive claims, but simply deals with matters that should have been raised in the earlier appeal. So if my learned friend has to say, go back to 94, which is the significance of the point I've just made, but the conclusion that the Court of Appeal draw, having done that extensive analysis, is set out at paragraph 30 on page 1440, and it leads them to that conclusion. Should have said that in relation to section 96, you might want to write next door to para 29 in ZA, see also Lady Hale in BA Nigeria at paragraph 41, where my lady said these new powers are not apt to cater for repetitious claims, which I think in context can be taken as meaning not apt to cover them either in their entirety or so as to denude 353 of practical impact. So that's an important section in ZA and goes directly to answer the claim that you don't need to bother about any of this anymore. 353 is a dead letter because you already have anti-abuse provisions in the new structure of the legislation. True it is you do, but the coverage is not complete for the reasons that they give. And the real question, going back to the approach that Lord Neuberger identified at paragraph 24, is whether they can exist alongside each other and in combination. Because if they can, it's plainly much more consistent with what can be imputed as policy intention to Parliament. It's much more consistent with that to make them work together. Because the more efficient and effective the management and handling of those claims and the avoidance of repetition and abuse, the better.
Is it odd that out-of-country claims are not put through that filter? Because Rule 353 doesn't apply to them.
Well, my lady, we're not sure. I think that was the question I was going to come back to Lord Wilson on.
Right.
And I'm afraid at the moment I don't have clear instructions on quite what the answer to that is. I don't want to be casting any aspersions or blame at all, but we don't think that was raised, or if it was raised, it wasn't raised squarely, that issue in the case that my learned friend has advanced. And what we were going to do was to seek permission for me to take proper instructions on that to write.
It's simply that if you are saying this will plug a gap, it's not complete coverage if it's not going to apply to out-of-country claims.
It isn't complete coverage if that's right.
That's right. If that's right. I'm obviously this is on the premise that this is right.
And what I wanted to do is to reserve the right to take some proper instructions, if I may, and put in something very short to explain
Well,
that.
the essential point is, does claim in section 94 have two completely different meanings, depending on whether it's a claim that's made out of country or in country?
Well, that issue, my learned friend, I know, says arises anyway, and arises as a result of
yes, but in this precise context,
Yes.
which is, I think, the point that my lady is raising.
My lady, I'll have to check whether...
And we are used to, sometimes, the same word meaning different things in different sections,
Depending
but the same word in the same section should mean something different. In different factual contexts is a bit more...
It is, but as I say...
Well, you'll take instructions and you'll...
Yeah, I'll take instructions on that specific aspect of it.
Tell us what the answer is, yes. Well, tell us what your instructions are, the answer is.
I will. Anyway, 94 to 96, that's what we say about that. The conclusion of paragraph 30 is we respectfully submit correct. And again, back, if you would, or if you need to in the same bundle, to the Hussain decision and Lord Justice Beatson in Wacker.
Well, this is the third time you've gone to that. You know the rules about about quoting from refusals of permission. I suppose you can wriggle out of it on the basis it's
in
in a reported decision.
Yes, and I'm not going back to...
Nevertheless, Mr. Reedy.
I'm not going back to it for to establish any proposition. It's merely as a crisp summary
Very well.
of the submissions I've already made
Good,
about
thank
what
you.
ZA says. Anyway, I won't trouble your patience. It's para 21 if you want it on this issue. So we respectfully submit that the availability of certification does not favour or lead to a different interpretation of the word claim. The question is whether the Act and 353 can be read and can operate in combination. That was the Lord Neuberger question of approach. And the answer that he gave, echoed in VM Jamaica, was yes. And you end up, we would add, with a better and more complete protection if they do operate in combination. Hard it is, we submit, to see any reason, whatever, why Parliament would not want that, or would want the alternative, allowing for some repetitive or hopeless repeat claims having a right of appeal. The sixth and final submission, then, is that there is nothing in the 2014 legislative changes to support a different conclusion or to treat 353 as a dead letter under that scheme. There have been lots of attempts to argue that that was the effect, in a variety of different contexts, of the 2014 changes, and all have to date failed. It's not to say you can't disagree with them, but those arguments were mounted in WACA, in MG, which raised a slightly different set of issues, Mr. Justice Blake again, but this time sitting in the upper tribunal with Upper Tribunal Judge Grubb. That's at tab 25, short decision there. Hussein itself and VM Jamaica. And my overarching submission is that nothing in the 2014 Act supports the proposition that Parliament intended by the amendments it made to reverse the position, as I've submitted it is, or was under the 2000 legislation, so that any and all repetitious claims would now generate a right of appeal. And that is my learned friend's case. And the key points that we make on that are that it would be very surprising if that was the result, given the clear public interest in controlling such an outcome, and you would expect a very clear indication if that were indeed Parliament's intention. And you would doubly expect a very clear indication if that was their intention, given the position reached in the case law. Subject to the narrow BA exception, claim means first or subsequent non-repetitious claims. And rather than having any form of clarity of that kind in the 2014 Act, we respectfully submit, on the contrary, that the amendments made are entirely consistent with an intention to stick in that place. And that is not least because, as Mr. Justice Blake put it in the MG decision to which I've just referred, tab 25 in bundle 4, MS 1474, paragraph 14, wrong, maybe a false reference. Check. It's paragraph 14, first sentence, where he says Parliament can be presumed to have legislated against the background of satisfaction with the previous law as declared in ZA Nigeria. And that isn't a repetition of the argument that was rejected in BA, as Melanie Friend sought to characterise it this morning, because since BA, there has been a consideration by the Court of Appeal in ZA Nigeria, with a permission to appeal application being refused by the Supreme Court, as to how BA can be squared with ZT Kosovo, leading to the ZA outcome, which then stood for 4 years before this legislation was enacted. So
but it's Lady Hale's approach, updated, isn't it? It's the application of the informed interpretation rule
it is.
that she was adopting,
But
updated to post-2014. Is that right?
It is.
But I was in a minority,
You were in a minority.
so I loyally follow the majority subsequently.
You were in a minority then. The question is, does that undermine the reasoning that my lady advanced? And my respectful submission is not CZA, which actually did the reconciliation between ZT Kosovo and BA Nigeria. But it was that informed interpretation that then hits the 2014 Act.
I mean, there are two separate questions. One is what is meant by a claim, which might have the onibio meaning generally, and who decides whether or not it's a claim. Those are two separate questions, and I was deciding the first of those, but not the second. I was not saying, it was specifically, Miss Lang was not arguing that it always had to be the Secretary of State deciding.
No, my lady, well, that's true. So there's a precedent fact issue, and there's all the issues we saw explored.
But I take the point that onibio thought it probably was.
I think when Mr. Fordham, perhaps he'll, if I'm wrong, he'll say so, but I think when Mr. Fordham says it's for the tribunal to decide claim, I don't think he's saying it decides it in an onibio sense. It decides it because the claim is allegedly a straightforward thing to recognise.
No, I don't.
Is he not saying that?
I believe you're right.
Yes.
He'll tell us. He'll tell us if you're not. But
He'll tell us,
I believe you're right. But there is this middle way of looking at things.
Yes, I mean, neither party, I think, has done extensive submissions on that.
You have not. No, that's why I'm mentioning it.
But well, you know what my case is. Yes. My case is every time anyone's looked at this issue, Kaka Bay and onwards, they have decided that this is properly for the Secretary of State, because it sits as a
subject to judicial review.
Subject to a judicial review,
yeah.
Which brings in...
The contrary argument is that Rule 353 is really only directed at immigration decisions.
Yes, well, I'll come to that, but
Yes, please do.
We respectfully submit that's different given the structure, but I'll come to that structural change, if I may. Anyway, the point I was on at the moment was that the principle of informed legislation, as it were, in 2014 takes account of all the case law that has been decided and the settled position that has been reached at 2014. And that we respectfully submit includes ZA. Hussein also has drawn attention, if you go back to that, and this is Hussein rather than Hussein citing Beatson. So paras 43 and 44. So you'll see that the key issue, just go back a stage, 1504, behind tab 26 of bundle 4, you'll see that the essential argument and reasoning in Hussein started from para 37 and the conclusion there, which is that they are bound by the ratio of ZA Nigeria, and you see it there set out in 37. And then the question that then arose for them to consider was whether there had been any developments subsequently to lead to some different outcome. So that's the key issue that they are on. And you see the conclusion that they reach in 42, at the bottom of, towards the bottom of page 1504. The concept of claim remains central, which is significant for the reason they give. And they also then go on to analyse the changes that have been made to 353. in 43 and 44 they analysed that. I'm not sure. We'll have to between us double check that you've got all the versions of 353, because it looks from 44 as though there were some amendments to 353 to take account of the new structure under the 2014 Act. So we'll just make sure you've got all of those.
Are you saying we've not got the up-to-date?
Well, I'll have to check which precise version that they're referring to here, and whether it's exactly the same one that you've got in the bundles. But
I also wondered whether, because we've got 1996, which actually is version 2 of the rule, was it 346 then?
346 then?
Yeah, right, 1996. Then we've got 2004.
Yeah.
And it did cross my mind that when the Human Rights Act came in 2000, wouldn't there have been needed to have been an amendment of the rule?
In October 2000.
Because the rule was only applying to asylum, isn't it, up to that point? Wasn't it?
It was. We better check to make sure we've got all of them. But the reason in part for going here was because when I reread 44 over the shorter German, I thought, crikey, I'm not sure we've got... It's plain that there were some changes consequential on the 2014 Act. Ah. So we'll have to give you the derivation. That's the point that's being made at para 44 here. Right.
July 2015.
Thanks. So is that the most up-to-date?
July 2015 is at volume 1, tab 3.
Did you take him to that this morning? Yes, it's a 2015 one, so you probably do have the most up-to-date one, but you may not have an intermediate one. It's at 646, and I think that's the one my learned friend took you to this morning. You see the date for which that's valid on page 607, which is July 2015 to August 2015 at least.
Sir James, it may be that a small table
Yes,
with
my lord,
a clip of the various versions, only one clause, would assist.
Certainly would.
Yeah,
Thank you.
we'll certainly do that and make sure you have all the ones referenced into the bundles you do have, and if there are any missing in the sequence, we'll add them in. But back to, if I may, to para 44 on to make the positive point at 1505. So back in Hussein bundle 4, tab 26, page 1505, para 44, where the upper tribunal are making a point, in effect, that 353, this is against it now being a dead letter, 353 is now amended to include the new structure of the 2014 Act, effectively. My learned friend relies, and I've come back to, I've given the substance of the answer already, so I can take it shortly in answer to a question that my Lady Arden posed. But to come to section 12.3 of the 2006 Act, know the essential structure of that piece of legislation, which hasn't yet been, or hasn't been brought into, hasn't been commenced. We make the point in our case at paragraph 62, which may be all we need for this purpose, that as the explanatory notes record, they're behind tab 17, the amendment to the definitions of human rights claim and asylum claim in section 113 of the 2002 Act was made, quote, to clarify.
What page are we on here?
I'm taking the quote from our case as the most convenient way of doing it. MS 146, it's paragraph 62 of the case.
Yes.
And if you wanted the reference to the explanatory notes, if you have a version of the case maybe that didn't have the references yet inserted, it's behind tab 17, the 2006 Act explanatory notes. But you see that their purpose was to clarify. And my submission is that there was, therefore, the natural inference is that there was no need to commence those provisions because it was considered that it was clear already. The position had been clarified, so there was no need to commence those. But if anything, as I indicated earlier or submitted earlier, those provisions, i.e. the new provisions not commenced, indicate a parliamentary intention at least to allow for the statutory replication of 353 or its equivalent. And so the question is, well, what are the alternative explanations for why they haven't been commenced or brought into force? And one of them, of course, is that it wasn't considered necessary, given that the law was clear anyway through the jurisprudence, and 353 and the legislative provisions could operate in combination, VM Jamaica. And the other one, the only other alternative explanation, is that there'd been some form of change of heart, and it was decided that the scheme could and should operate without 353 or anything like it.
It isn't a complete replication of 353, though, is it? Because the way that 353 has been interpreted, it stops something being a claim. And this one allows for it to be a claim.
That's my point.
Is that your point?
Yes. And therefore, it could be that having looked at it, it was considered that it would cause more trouble to bring it in than to leave the situation as it was.
Yes.
It's just a possibility.
Well, I mean, maybe the true answer to all of this is it's unclear precisely why they weren't brought into effect, why they weren't commenced, but the fact of the matter is they haven't been. Can I give you one reference on this set of issues, which may or may not assist you in answering that question, because the upper tribunal specifically considered arguments based on 12.3 and the non-bringing into effect and so on in the Hussein decision. So that was bundle 4, tab 26, and the relevant paragraph numbers are 45 to 48. So they quite deal with the point my Lady Arden was making then, but those paragraphs may at least be of some assistance. So 45 to 48 on 1505.
That whole discussion from Hussein is extremely helpful and clear. Whether it's correct or not is another matter, but it's very helpful.
But at least they are there considering, that's why I pointed to the structure of the judgment, they're there considering all the various changes that have been made or not made since 2014 came in. So that's 12.3. My learned friend then relies on the change of structure from immigration being the subject of the appeal right to the rejection of the human rights or asylum claim itself. But we respectfully submit that can't bear the weight to which he attaches to it. It can't bear that weight because all of the analysis, particularly in ZA, is not, as it were, premised on that narrow distinction, because it didn't need to be, for obvious reasons, but it isn't premised on that narrow distinction. And what has in fact happened is, in essence, to retain the structure, so there are appealable decisions, there are claims and so on, but to restrict the number from the previous 14 immigration decisions down to 3. And that, it appears, not least from the explanatory notes as we've cited in our case, was intended to limit, or at the very least to restructure, not to expand appeals, not to open the door to limitless consecutive appeals of the kind that concerned the courts in the bits I took you to at first things when I started my submissions. And there's nothing to suggest in those changes that claim should mean something different, or that it's suddenly a good idea, and Parliament considered it was suddenly a good idea to open up appeals just because the person has chosen to make a repetitious claim. That was the point made in paragraph 41 of Hussein. So the structure, the essential structure, remains the same. Is there a claim to be determined at all remains a live question. Pre the 2014 Act amendments, if we're right, if there was no claim to determine, there was no need for an immigration decision. But post the 2014 Act amendments, if there's no claim to determine, there's no human rights claim or protection claim to be refused. There are simply further submissions to be rejected. what's happened is you simply don't need, it's not tied to the subsequent immigration decision now. And the fact that the concept of a human rights claim is defined takes the argument no further, because the definition simply refers back again to the concept of a claim. So it's question begging. The question remains, what was the claim intended to mean? Was there intended to be, through this change of structure, some fundamental alteration of the prior position? Well, if there was, then that's a very strange way of doing it, I respectfully submit, because you maintain the same essential structure, you shrink 14 down to 3, no doubt for reasons of simplicity and probably to limit rather than expand. And then my learned friend says, well, now you have unlimited ability to make repeat claims in whatever shape or form you wish. And to the extent that 94 and 96 don't cover it, and we know they don't cover it, then that doesn't matter. And for good measure, it's a subject dealt with in the cases, but my friend didn't touch on it much orally, but you'll see from our case that the Secretary of State's processes, in effect the 3-stage process that we refer to in the case, have essentially remained exactly the same before and after. Again, that is a subject on which there was some discussion and some analysis, leading essentially to the conclusion it all remains the same. In Hussein again, analysing the subsequent changes, see for this purpose and on this point, paras 53 to 56 of the Hussein decision in the upper tribunal. Ladies and my lords, those are my submissions, subject to checking the 353 out of the jurisdiction point, unless there are further matters on which...
And supplying us with...
the table.
All the various versions
We'll make very sure you have
the
that.
law in due course. I think there are no further questions, Sir James. Mr. Blundell? You've appeared in so many of these cases yourself that it must feel very much like déjà vu for you.
We're going to be addressed on 353 out of the jurisdiction, having twisted his arm right behind his back. It was going to be Mr. Blundell anyway, so he's been spared that.
I hope Mr. Hussein is not suffering too much discomfort watching, but Mr. Toll is in a similar position, as you'll have seen from these.
Yes.
Indeed,
It's just
yes,
a few
we have.
points in reply from someone who wasn't. We have to remember we're construing claim in Part 5. And nobody is saying that claim in Part 5 changed in 2014. I'm certainly not saying it. Claim has continued to mean what it was held in BA Nigeria to mean. You've just heard Sir James. He disavows there having been any change in 2014. So we are entitled to start by asking, well, if it's being said that claim in Part 5 now means it's a claim if the Secretary of State classifies it under the immigration rules as a claim, or it means it's a claim if the acid test is applicable to it. Given that it didn't mean that in Section 92 or Section 94 or Section 96 in BA Nigeria, we're entitled to ask, when did it change? And we're entitled to ask, where has it changed? Are you saying throughout Part 5? Or are you saying in different provisions of Part 5? And a simple way to test the argument is to go back to that language of 92, 94 and 96, where it is directly equivalent language to that which the Supreme Court considered in BA. Are you now saying, Sir James, that when we see that word claim in Section 96, it has a different meaning from the meaning it was given by 4 out of the 5 judges in BA Nigeria? And if you are saying that, when did that change and why did it change? And is it a meaning that changes in different provisions within Part 5? Certainly ZA never said that claim in Part 5 had an onibio meaning. And in fact, if you think about it, take Sir James's Venn diagram that we were just on. He says, look at ZA, it all operates side by side. You can have Rule 353, you can have 94, you can have 96. How can you have 94 and 96 applicable to something which wouldn't meet the onibio test? You can only have it applicable if the Part 5 meaning of claim is the one that BA Nigeria found. Who decides? We saw Kakebe and that section on classification and the role of the Secretary of State. But as you know, because I showed you the passage, that was in the context of the Secretary of State making a decision, an immigration decision, on leave to enter. Am I going to give it? Am I going to refuse it? Or am I simply going to say I'm not making a decision? And that's the role that the Secretary of State is exercising under the then framework, which is why you've got the Secretary of State with a gatekeeper function making a decision. Because I'm the Secretary of State, these are my rules, I decide what to do about leave to enter.
But the refusal of a claim is a decision in one sense, isn't it?
Yes, it is. And the refusal of a claim would be straightforwardly within Section 82 of Part 5. So
you are, as Sir James said, you're placing an awful lot of weight on the fact that there were all these various decisions prior to 2014 that you could appeal against, and you say that is the context in which these decisions were made. For myself, I slightly struggle to see the significance of your saying, well, that's all about decisions, because a refusal of a human rights claim, which is now appealable, is a decision in the broad sense.
Certainly, but as I explained first thing this morning, there's no dispute between us that we've got the decision to refuse part.
Quite.
The question is, have we got the claim part?
Yes.
And it really comes to this. The Secretary of State being given a role within Part 5 of the 2002 Act to certify whether something's a claim, because those provisions are necessarily going to need to be applied by the tribunal. Is there a right of appeal? Is there a decision to refuse? Was there a claim? And what's being said is gatekeeper function. Secretary of State gets to say whether or not there is a claim, and that's then a collateral judicial review challenge. Now, you could have that structure, but 2 points about that. First of all, that would be akin to the certification functions that we get. The Secretary of State can certify that. For example, a point could and should have reasonably been taken previously. That's something that he can judge, and you certify. And you could have a provision that says it's for the Secretary of State to certify whether something constitutes a claim. That would still be a change from the straightforward we submit statutory scheme with which the Supreme Court was concerned in BA. That's the first point. But the second point is that, as my Lady Hell put to Sir James, in the dissenting judgment in that case, you were very clear that that was an operation of the statute argument, that by operation of the Act, in the Act, claim for everyone who's applying it has the onibio meaning. It's not a gatekeeping function, because if it were for the Secretary of State to decide in accordance with the rules can change tomorrow and shift the approach that the Secretary of State can have, just as humanitarian protection might change tomorrow in its definition. And that's never been there within the scheme. And Sir James can't identify any time in which that arose, nor was ZA saying for a moment that that had somehow been introduced. So when Sir James says, and he rightly says, that the really important passage in ZA is the conclusion at paragraph 59, the bottom of 1447, I couldn't agree more. Where there is an appealable immigration decision, that's the point my Lord Wilson was just putting to me that I'm putting a lot of weight on. Lord Neuberger putting weight on that point. Once there is such a decision, the complete code, has no part to play. The immigration decision is not, I'm not recognising this as a claim. The immigration decision is about leave to enter, it's about refusal to revoke deportation order, and so on and so forth. And that's why all of that material about Secretary of State getting to decide is explicable when you see immigration decisions on leave to enter pursuant to the immigration rules. The idea that ZA, as Mr. Eadie has submitted, was putting side by side as both having a role, Rule 353, which can sometimes mean you haven't got the immigration decision, and then Section 94 and 96, which, notwithstanding that the fresh claim test is not met, can be applicable to what is a claim under the statute. That's his analysis, and that's what he's put forward. And that's quite right, but it's only right because of what I've just said. It's only right because what ZA was saying is that 353 can have a role in relation to the immigration decision on leave to enter. And the fact that it is conceded, as it just was, that 94 and 96 continued to operate in a case that has been negatively classified, once you've got an immigration decision, that's what Lord Neuberger says, that's what Sir James Eadie has accepted, tells you that when you go back to the statutory wording of Section 94, claim, and when you go back to the statutory wording of Section 96, claim doesn't mean onibaya. Claim means BA. Because otherwise there's no Venn diagram. There's no two things operating side by side. There would only be one show in town. And the gatekeeping function would mean you don't get into Part 5 of the Act at all because of an immigration rule. And that would be reading in precisely what Lady Hale, dissenting, was not prepared to read in BA. If ZA were saying that claim had a different meaning in different situations, you'd be able to point to it on the page where Lord Neuberger is saying it, and it would be in the section of his judgment where he's actually considered the authority. That's not what he's saying. What he's saying is there's an immigration decision aspect under the legislation as it was. And it's interesting, I took you to the divisional court in ZA, and I said in two sentences, it unlocked all of this. It was at page 1414, and I showed you counsel, very experienced counsel who's in all these cases, and the submission that had been made. And I showed you the divisional court at 1414, tab 22 of volume 4, because it really does explain everything that's going on in ZA given BA. And the two sentences we saw with these, Sir James hasn't an answer to them. Rule 353 has no part to play in determining whether a renewed submission is an asylum claim or a human rights claim, which is what BA Nigeria decided. Correct, we submit. It does have a part to play in determining whether the Secretary of State should make an appealable immigration decision consequent on the renewed submission. That BA Nigeria did not address. So that's why we've emphasised the point in the way that we have. And the problem Sir James has is he has to leap from the final sentence to the penultimate sentence to win this case. He has to get you to decide that actually Rule 353 does have a part to play in determining whether it's an asylum claim or human rights claim under the Act. And he then has to explain when that happened and where in the statute it happened and why it happened. And with the greatest of respect, I submit that he's not been able to answer any of those questions because it's really much simpler than that.
Could I just ask you about section 96, please, just going
Yes.
back a moment. In 96(1)(b), there's a reference to the claim or application to which the new decision relates.
Yes.
What's the difference between those two?
Just give me one moment, I'm just going
Yes.
to turn it up.
505.
Yes. The
Well, I suppose you might make a claim for asylum, but an application for leave to enter.
well, exactly, and this language is a carryover from the pre-2014 world, where that was precisely so, because you needed the immigration decision. And in fact, it's not the only example of that. You saw first thing this morning that Section 113 continues to define asylum claim. Asylum claim no longer appears anywhere in Part 5 because it's all now dealt with under protection claim. My submission is that there will, and only ever will, be a claim to which the decision, the new decision relates. And that is because the decision is a decision to refuse a protection claim or a human rights claim. It may be that learned friends are able to point me in the direction of something that gives another answer to that question. If and to the extent that application is relevant and still relevant, then my submission would have to be it's really synonymous to application. Suppose the rules talk about application for humanitarian protection. Then it's rather similar to what we had earlier with rejection and refusal. Is there anything else?
Mr. Fordham, how can you say that Section 94 covers, in effect, the same ground as Rule 353, when Section 94 gives one an appeal, albeit out of country, whereas Rule 353 prevents one from having it at all?
I don't submit to the court that it has the same consequence. If that were the position, none of us would be here. And indeed, it would have been exactly the same in BA Nigeria when the court was looking at safeguards, and the same argument was being run. 353 bites, there is no appeal. So what the submission is that there are within the statute the safeguards that have been considered appropriate within Part 5 to deal with the sorts of abuse that are being pointed to. And so there is a safeguard. What was also said in BA, and I would respectfully maintain, is this. To deal with an abuse, alleged abuse, through a certification power that leads to an out-of-country appeal, from a policy perspective, has a compelling logic to it when one recalls that the spectrum of cases that are being taken out here include the repetitious claim, but are not limited to the repetitious claim. We're not dealing with repeat claims, how do we deal with that abuse? We're dealing with subsequent claims. And subsequent claims may, at one extreme, be a mere repetition. But at the other extreme will be something utterly distinctive that is considered not to have a realistic prospect. And that's the category with which we are concerned. But you're right to pick me up on it. The submission is that is a safeguard within the statutory scheme that deals with that group of claims. And to point to something at the extreme and say it's obvious that public policy requires that there be no right of appeal at all is answered by the fact that the policy of the statute can be found in the design of the statute, and if Parliament wants to change it, it can do so.
We mustn't forget the context is, just remember the whole time, there's been a refusal and there's been an appeal or an opportunity for appeal.
Correct.
So that's the context in which all this arises.
Yes.
And you say the only situation in which some further attempt to make a claim or some further submission can be blocked out from having any appeal at all is the pretty narrow Section 96 situation.
Subject to amendment, yes, I submit that the course that takes the, I will say extreme, but the most complete, if you like, inhibiting course is expressly addressed in the legislation in section 96. And I've already made this point, but I make it again. It's in our printed case at 18.7. That Parliament can perfectly well include a tailored provision for a repeat claim, because section 96 subsection 3 originally did that. If it's the same, Secretary of State can certify it, and that means no appeal. So let me round off then on this important point about public policy, the powerful public interest with which Sir James began his submissions. We must remember, firstly, that the two appellants that were before the BA Supreme Court were in materially the same position as my client. They had made their subsequent submissions. They'd been considered on the merits and rejected. They'd been assessed as not meeting the Rule 353 claim, and the Secretary of State had said, I'm not going to revoke the deportation order. So there is a direct symmetry from a policy perspective in relation to the arguments that you have just heard and the Supreme Court heard in that very case. Exactly the same premise. But you've been assessed as having no reason, you've got a judicial review right, and so on and so forth. And you'll see all of that from the decision letters. We summarised them in paragraphs 5 and paragraph 7. The second point is the one I've just made. We must always remember with these policy arguments that although it's easy to emphasise repetitive claims, the group of cases with which we are concerned have that at one end, but have the other situations where it might be utterly distinctive, but it's said not to have a realistic prospect. And it is worth recalling, as we say in our case at 18.1, that Mr. Etame, who was the claimant in that very case of BA, actually went on to win his appeal, the appeal that he had. So it's all very well to say, well, you've certified it, of course you do your best, there's a rationality test, and of course that's applied, and of course judicial review has an important role. But we must remember when we're looking at abuse, the range of cases that we are concerned with. The third thing we have to remember is that the Secretary of State accepts that he has to consider these letters and deal with them on their merits. And you'll be impressed when you look in the bundles at E359 and E344 that that's what's done. In fact, the rule itself requires it, the rule that's being invoked. So in terms of abuse, this is not a case about, oh, here's someone writing another letter. Dear Supreme Court, will you please lift this burden so we don't have to consider these things? That part of it is common ground. And it's common ground that they have to be dealt with and that they are dealt with. So that's not what we're here to argue about. In the end, what we're here to argue about is whether the policy position is properly dealt with under the primary legislation where appropriate powers are identifiable, and it will mean that a certificate, if one is issued, that a case is clearly unfounded, will lead to an out-of-country appeal, which may, I showed you this, not involve any hearing. And I was reminded, and I forgot to show you this, there's a provision in the legislation, in case you're worried about it, that deals with the problem of whether continued submissions and continued decision letters means you have to have separate appeals, and you don't, because what the tribunal deals with under the legislation is the whole series of appealable decisions. I didn't show you it this morning, and so I therefore need to tell you what it is. It's section 85, subsection 1 on page 493. So there's no problem about you've got to case manage a whole load of different appeals just because different letters were written and dealt with. Lord Bingham's, or Sir Thomas Bingham's, policing of the hinterland, which Sir James took you to, you'll recall had its Laden-Marshall point, and that's what he called it, and it had its point against the backcloth of a no second appeal certificate, frivolous or vexatious. But you know that that was what Lord Brown was specifically addressing in his judgment in BA Nigeria, with which the other members of the court specifically agreed. Those now have their analogues in primary legislation with appropriate safeguards. And I ought to ensure that the court has in mind that so far as policy is concerned, as we set out in our printed case at paragraph 42, which you'll find in the printed case at the bottom of page 113, BA does not stand alone in having dealt with these sorts of policy arguments, because Carrie Harran, from which we quote at the bottom of 113, a decision of the Court of Appeal in 2002, dealt with exactly these sorts of arguments in the context of the 1999 Act, and the quote at the bottom of 113 is the abuse concern that was being expressed by the Secretary of State, and the way the court dealt with it in the judgment, which is in tab 11 of volume 2, is then summarised for you at the top of 114, and all there set out. So one just takes the meaning of the statute and the safeguards that Parliament has identified. Similarly, you'll find the same sort of principled approach at the bottom of our paragraph 26 on page 99, bottom of the page. I didn't read all of this out this morning. I'm not going to read it out now either, but I don't want you to think BA Nigeria somehow stands alone as a beacon in terms of responding to arguments about abuse by saying, well, look at the legislation and give it its natural meaning. That's not a new idea at all. And you'll see from the passage from AS Somalia that that's long since been the position. It's one that we respectfully invite this court to hold to. So far as, finally, the Venn diagram and whether there is really a gap here so far as abuse is concerned, the Secretary of State has to say that the gap is that someone gets an out-of-country appeal rather than no appeal at all. But that is the consequence of the application of the safeguards within the primary legislation. It is a consequence which we respectfully submit is one to be embraced. And it is to be embraced because of the range of situations that are in place in this area, and given the magnitude and significance of these sorts of decisions. But if there is a policy imperative that is felt to justify introducing a gatekeeping role within Section 5, it will need to be carefully designed. There are important policy questions about whether that's just repeat claims or whether it really is claims that have a no realistic or no reasonable prospect. There is an important policy question as to why it is that no realistic prospect should be treated as in a different way in principle than clearly unfounded when you are not in a repeat claim world, you're in a distinctive claim world. And what is the justification that drives such a distinction? And those judgments are judgments that Parliament needs to grapple with through the primary legislation. I said it, and it may have been simplistic when I said it, but I maintain it. Claim means the same and has meant the same throughout in Part 5 and throughout Part 5. And yes, it needs to be applied, including by the tribunal, to see what it means. But what it means has its statutory meaning. It is defined within the statute. It has an ordinary and natural meaning. It is not appropriate to gloss it, to introduce executive discretions that aren't spelt out in the statutory scheme. And if that is to be changed, that is a matter for Parliament. Unless I can assist further, those are our submissions in reply.
No, it appears not. Thank you very much indeed. Thank you. You are to be congratulated in taking slightly less than a day to cover what has turned out to be really quite a lot of ground. So we're grateful to everybody, those who have made submissions in writing, because I'm fairly sure that your juniors have played some considerable part. We should probably also be very grateful to Mr. Hussain, who will have played a part in the appellant case.
Yes, yes.
And of course we are to those of you who've been on your feet. And we will now go away and work out the answer.